There is a particular kind of silence that exists only on large tracts of undeveloped land in the early morning hours before the world has fully committed to being awake. It is not the absence of sound. There is always sound on land like that, the movement of animals through brush, the conversation of wind in the tree canopy, the occasional distant report of something settling in the wood. It is a silence underneath the sounds, a quality of air that exists only when there are no roads within earshot, and no artificial lights visible, and nothing between you and the sky, except whatever weather the sky has decided to bring that morning. I have been chasing that silence since I was 8 years old, walking my grandfather's pasture land in East Tennessee before sunrise, because my grandfather believed that boys who wanted to hunt had to learn to be still before they learned anything else. My name is Cole Branham. I am 51 years old. I am a third-generation timber and agricultural land owner in Harmon County, Tennessee, which means I grew up understanding land the way people understand language when they learn it before they can remember learning it, not as a subject, but as the medium through which everything else is understood. My grandfather owned 400 acres. My father grew it to 600 through 2 careful purchases over 30 years. I have grown it to 812 acres over 23 years, acquiring parcels as they became available from families who needed liquidity and trusted the name Branham to treat land right. 812 acres of mixed hardwood timber, creek bottom, open pasture, and ridgeline terrain that runs from the valley floor up to a ridge that looks west across 3 counties on a clear day. I have a timber operation on the eastern third of the property. I have a cattle operation on the pasture sections. I lease hunting rights to a club of 12 men I have known for 20 years and whose families have hunted this land almost as long as mine has. And for 17 years, I had a hunting lodge on a 7-acre parcel at the southwest corner of the property, a proper structure, not a glorified shed, but a full-built lodge with 4 bedrooms, a great room with a stone fireplace I laid myself, a covered porch that ran the full length of the south face, and a kitchen that could feed 12 men after a cold morning without complaint. I built it in 2 phases. The first phase took 1 summer and cost me $60,000 in materials, most of the labor being my own and the labor of men who owed me work and who I fed and paid for their time. The second phase, 3 years later, added the 2 rear bedrooms and the covered porch and the stone fireplace, which took me 6 weeks of evenings and 2 full weekends, and which I consider the finest single piece of construction I have ever completed. The lodge was insured, permitted, and assessed by the county as a residential structure on agricultural land. It was mine. It had been mine for 17 years. I need to explain the HOA because the HOA requires explanation. Harmon County, Tennessee is not a place you would typically associate with homeowners associations. It is a rural county with more cattle than people and more hollow roads than paved ones, and a general cultural disposition toward the idea that a man's land is his, and his business on it is his own, and the government and its various subsidiary organizations are welcome to stay on their side of the fence. This disposition is accurate and well-founded, and I share it. I did not choose to be part of a homeowners association. I did not sign a covenant. I did not submit to a declaration of restrictions. What I am part of, what I was made part of without my consent or knowledge until after the fact, is a rural landowners association called the Harmon County Agricultural Land Alliance, which was organized in 2003 by a group of property owners in the county's western district with the stated purpose of coordinating land use, managing shared road maintenance costs, and presenting a unified voice to county planning and zoning boards. It was not organized as an HOA in the legal sense. It had no authority over individual land use. Its founding documents said explicitly that membership conferred no rights over other members' land management decisions and that the organization was advisory only. I was not a member. I had never joined. I had never paid dues. I had never attended a meeting. In 2019, without my knowledge, the Harmon County Agricultural Land Alliance amended its organizational structure and adopted what it called a Community Standards Charter, a document that purported to give the Alliance governance authority over land use decisions on member properties. Still not my problem, since I was not a member. Except that the charter also contained a provision buried in Section 11, subsection F, of a 34-page document that was not circulated to non-members, stating that any property within the Alliance's designated geographic boundary was subject to the Charter's provisions regardless of membership status, on the theory that land use decisions affect the broader community regardless of whether individual landowners had chosen to affiliate. I found this out in the fall of 2021 when I received a letter from the Harmon County Agricultural Land Alliance informing me that my hunting lodge was in violation of the Alliance's charter provisions on commercial structures, specifically the provision prohibiting commercial operations within residential agricultural zones as defined by the charter. The letter said the lodge, which the Alliance had apparently categorized as a commercial hunting operation based on the fact that I leased hunting rights to the club, was required to be removed within 90 days or the Alliance would pursue enforcement action. I read that letter at my kitchen table on a Tuesday evening in October, and then I read it again more slowly. Then I called my friend Roy Gallagher, who had been practicing general law in Harmon County for 35 years, and who had the manner of a man who had seen most varieties of legal foolishness the rural South could produce, and had developed a measured calm about all of them. I read Roy the relevant sections of the letter over the phone. He was quiet for a moment. Then he said, "Cole, I'm going to need to see their founding documents, the charter, and the amendment history. This is either a serious overreach or a serious misunderstanding, and either way they don't have what they think they have." I said I would get him whatever he needed. He said, "First question, are you in their geographic boundary?" I said I had no idea. He said, "Find out tomorrow. That's the threshold question." I found out the next morning. I called the Alliance's administrative contact, a woman named Janet Fulton, who served as the organization's executive secretary and who was, as I would learn over the following months, a fundamentally decent person caught in the middle of something she had not designed. Janet confirmed that my property was within the Alliance's designated geographic boundary, which had been drawn in 2003 to encompass the Western District of Harmon County, and which I had not been told about in 2003 because I had not been identified as a party of interest in the initial organizing process. My property was in the boundary because geography does not require your opinion. I sent Roy everything I could find about the Alliance. He called me 3 days later. He said, "Cole, here is the situation. The Alliance's original founding documents, as you suspected, contain no enforcement authority and explicitly disclaim governance power over non-member land use. The 2019 Charter Amendment attempted to change that. Whether the amendment is legally effective is a real question. It requires analysis of whether a private organization can impose governance authority over non-member property through a unilateral document amendment. My preliminary view is that they cannot. Tennessee property law is clear that restrictions on land use must either be established in the deed itself, in a recorded covenant running with the land, or through government regulation. A private organization's internal charter does not meet any of those criteria." He paused. "But Cole, this will take time to litigate if they push it, and I want to know who is running this organization and why are they coming after your lodge?" That was the question that mattered, and the answer was Gerald Fitch. Gerald Fitch was 64 years old, had moved to Harmon County 11 years ago from Knoxville after selling a commercial real estate development business, and had purchased a 1,200-acre property adjacent to the Alliance's eastern boundary. He had joined the Alliance within 6 months of arriving, had been elected to the board within 2 years, and had been the Alliance's president for 5 consecutive years. He was, by most accounts I heard from people who had dealt with him, a man who had spent 30 years in commercial development learning how to use organizational structures to achieve outcomes that direct negotiation would not produce, and who had brought that skill set to rural land governance with an energy that the Alliance had not been designed to accommodate. Roy found out through his own networks in the county that Gerald Fitch had approached me through an intermediary about purchasing a right-of-way across the southwest corner of my property, the corner where the lodge sat, approximately 18 months before the violation letter arrived. I had declined that conversation. I had declined it through the intermediary, briefly and without detailed explanation, because I did not want a road across the southwest corner of my property, and I did not need to explain why to anyone who was not asking at my invitation. What Roy's sources suggested was that the route Fitch wanted was related to a planned expansion of his own operation that would have significantly reduced his equipment transit times by cutting across my land rather than going around it. The violation notice, in this context, looked rather different than it had on first reading. I sent Roy a full authorization to act on my behalf. He sent a response letter to the Alliance within 10 days of the original violation notice, stating that I was not a member of the Alliance, that the Charter's purported authority over non-member property was legally unsupported, that I was prepared to seek a declaratory judgment in circuit court to that effect, and that any attempt to enforce the Charter against my property, pending that determination, would be met with an immediate injunction application and a claim for attorney fees and costs under the Tennessee Frivolous Action Statute. The Alliance's response arrived 3 weeks later. It did not withdraw the violation notice. It did not acknowledge Roy's legal arguments. It said the Alliance was reviewing the matter and would respond in due course. It was signed by Janet Fulton, which told me the board had decided to make Janet the face of a communication they did not want to own themselves. I filed the declaratory judgment action in Harmon County Circuit Court in January of 2022. The case was assigned to Judge Patricia Morse, who had been on the bench in Harmon County for 16 years and who Roy described as thorough, fair, and reliably impatient with procedural games. The Alliance retained a Knoxville attorney named Douglas Hale, who filed a motion to dismiss, arguing that I lacked standing because the Charter's geographic authority provision was valid on its face. Roy responded with a brief that was 31 pages long and cited 19 Tennessee property law cases, which I read entirely because I believe a man who is fighting for his land should understand the fight. The motion to dismiss was denied in March. Judge Morse wrote in her order that the standing argument was unpersuasive given the plain language of Tennessee property law governing restrictive covenants and the equally plain absence of any recorded instrument establishing the Alliance's claimed authority over Mr. Branham's property. I read that order 3 times. The third time I read it out loud to my dogs, who were unimpressed but present. The case was scheduled for a merits hearing in September. That gave the Alliance 7 months during which their violation notice technically remained outstanding, and their 90-day compliance window had long since passed. In April, I received a second letter from the Alliance, again signed by Janet, stating that my non-compliance with the violation notice had been noted and that the Alliance would be taking appropriate action. Roy called me the day I received it and said he had already seen a copy through his contacts at the courthouse. He said, "Cole, they're going to do something, I don't know what, but Fitch is not a man who sits through a lawsuit without doing something on the ground while it proceeds. Watch your property." I said I understood. I had already increased the frequency of my property checks. I drove the full perimeter road twice a week rather than once. And I had given the hunting club members my cell number with instructions to call me immediately if they observed anything unusual. The call came on a Thursday morning in May. It was one of the club members, a man named Donnie Reese, who had been hunting my land for 15 years and who called me with the particular quality of controlled urgency in his voice that I recognized from the years I had spent around men who had learned to stay calm when things went wrong. He said, "Cole, you need to come to the lodge right now." I said, "What happened?" He said, "Just come." I drove the 7 miles from my house to the southwest corner of the property in 12 minutes on roads that did not technically support that speed, but that I knew well enough to manage. I turned onto the access road that led to the lodge, drove through the first gate, through the tree line, and out into the clearing where the lodge had stood for 17 years. The clearing was full of debris. The lodge was gone. Not damaged, not partially demolished. Gone. The structure had been taken down to the foundation. The stone fireplace I had laid by hand over 6 weeks of evenings was a pile of fieldstone and mortar fragments in the center of what had been the great room. The porch posts I had turned on my own lathe were splinters in the grass. The two rear bedrooms were a heap of framing lumber and insulation and sheetrock that had been pushed into the northeast corner of the site by what was clearly heavy equipment. I could see the track marks in the soft ground at the edges of the clearing, wide-spaced and deep-set, the signature of a large machine. The kitchen I could have fed 12 men from was matchsticks. I stood at the edge of the clearing for a long time. Donnie stood beside me and said nothing, which was the right thing to do. Then I took out my phone and called Roy Gallagher. Roy answered on the second ring. I said, "Roy, they demolished the lodge." There was a silence on his end that lasted about 4 seconds, which was the longest I had ever heard Roy Gallagher be silent. Then he said, "Cole, I need you to listen to me carefully. Do not touch anything. Photograph everything. Call the county sheriff right now and report a criminal destruction of property. I am getting in my car." I called the sheriff. I photographed everything, and I stood in the clearing where my lodge had been and looked at the track marks in the ground and thought about what I was going to do, which was a thought I needed to be careful with because the things I wanted to do in that moment were not all things I was going to do, and the distance between wanting and doing is a distance I have always maintained and was going to maintain now regardless of how large the debris pile was. Roy arrived 40 minutes later. The sheriff's deputy, a man named Travis Goad who had known my family for 20 years, arrived 15 minutes after that. Travis documented everything: the debris, the track marks, the access road, the gate at the property entrance, which showed signs of having been forced open and then closed again. He said, "Cole, this is criminal destruction of property. It's also potentially criminal trespass with a vehicle. I'm going to need to know if you have any surveillance on this access road." I said I had a camera on the main gate that recorded to a local drive. I said I would pull the footage. The footage showed 2 vehicles entering my property through the forced gate at 4:47 in the morning on Thursday, a pickup truck and a skid steer on a trailer. The faces of the individuals involved were not clearly visible in the pre-dawn darkness, but the license plate of the pickup truck was visible in the enhanced still image that Travis's department produced from the footage. The plate came back registered to a limited liability company. The LLC's registered agent was a Knoxville business services firm. Roy had the LLC's ownership traced within 48 hours through a combination of public records and a contact at the Secretary of State's office. The LLC was controlled by a holding company. The holding company had 2 members. One of them was Gerald Fitch. Roy Gallagher sat at my kitchen table that Thursday evening with his reading glasses on and a yellow legal pad in front of him and wrote for 40 minutes without stopping. When he finished, he set the pen down and looked at me over the glasses and said, "Cole, I want to walk you through what we have and what it means, and then I want you to tell me what outcome you want, because the outcome you want is going to determine what I file and when." I said, "Walk me through it." He said we had the following: a criminal destruction of property complaint already filed with the sheriff's office, supported by photographic documentation and gate camera footage showing the vehicles entering my property in the pre-dawn hours. We had a trace connecting the pickup truck's license plate to an LLC connected to Gerald Fitch through a 2-layer corporate structure that was not particularly sophisticated as these things go. We had the pending declaratory judgment action in circuit court, now significantly supplemented by a factual record showing that the alliance's position had not remained merely legal. It had manifested in the physical destruction of a permitted, insured, county-assessed structure on my property without a court order, without any lawful authority, and without my knowledge or consent. He said this last point was the critical one. Regardless of whatever the alliance believed about its charter authority, regardless of whether the circuit court ultimately agreed or disagreed with their legal position, no court had issued any order authorizing the demolition of my lodge. There was no injunction. There was no enforcement order. There was not even a hearing date at which such an order could theoretically have been issued. What had happened was that individuals connected to the alliance's president had come onto my property in the dark and demolished my lodge on the theory that they were entitled to, which was not how enforcement of any legal instrument worked at any level of the American legal system. You did not self-help demolish a man's structure based on a private organization's internal charter, while that charter's legal validity was actively being litigated in the circuit court of the county in which the structure stood. Roy said, "Cole, this is not just a civil matter anymore. Travis Goad's investigation could result in criminal charges for criminal trespass and criminal destruction of property under Tennessee law, which at the value of that lodge is a Class C felony. That is not my case, that is the district attorney's case. What is my case is the civil action, which I am going to amend tomorrow morning to add claims for trespass, conversion, intentional destruction of property, and civil conspiracy. I'm also going to seek a temporary restraining order preventing any further action on or against your property pending the resolution of the litigation." He paused. "And I'm going to call Douglas Hale tonight and tell him what we have, because Douglas Hale is a professional, and when he understands what his client has done, he is going to have a serious conversation with Gerald Fitch that Gerald Fitch needs to have." I said that all sounded right. I said I had one more thing I wanted to do before we talked further about the civil case. Roy said, "What was that?" I said I wanted to talk to you about my bulldozer. Roy took off his reading glasses. I said I want to be clear about something before I explain. I had a D6 Caterpillar bulldozer, a mid-sized track machine that I use for land clearing, road maintenance, and the occasional drainage work on the property. It lived in my equipment barn on the eastern section. It had nothing to do with anything that had happened. But the Alliance, I had learned that afternoon from a conversation with Donnie Reese, had installed a cable gate across my main access road sometime in the past 2 weeks, the same road that ran through the Alliance's adjacent common access corridor and connected my property to the county road. The cable gate had an Alliance padlock on it. My access road, my right-of-way, established in the original property deed and confirmed in the county plat. A cable and a padlock that did not belong there. I said, "Roy, I want to take the bulldozer down the access road, remove the cable gate, and clear it. The right-of-way is mine. The gate does not belong there. I am not going onto anyone else's property. I am clearing an obstruction from my own legally established right-of-way." He looked at me for a long moment. Then he said, "Cole, in principle you are correct. A property owner has the right to remove an unauthorized obstruction from their deeded right-of-way. The cable gate, if it is indeed on your deeded right-of-way, has no legal basis for being there." He put the glasses back on. "In practice, I want you to document the gate thoroughly before you touch it. I want photographs of the gate, the padlock, the Alliance marking, and the right-of-way boundary markers on both sides. I want you to call Travis Goad and tell him what you are doing and why before you start the machine. And I want you to use the minimum force necessary to remove the obstruction." He paused. "A D6 is not minimum force, Cole." I said I was not going to use the blade. I was going to use the machine to push the gate post at its base where it had been driven into my road surface. One clean movement, post out of the ground, cable and gate moved to the side of the road, access restored. Roy said, "Document everything, call Travis first." I called Travis at 7 in the morning. He said, "Cole, I'd come out and watch, but I'm going to be busy with what you brought me yesterday. You're on your deeded right-of-way?" I said yes, I had the deed in my hand. He said, "Document it and do what you need to do. If anyone raises a complaint with this office, I'll tell them to call Roy." I said I appreciated that. He said, "Cole, I've known your family 30 years. That lodge was a piece of work." I said yes, it was. He said, "Build it back." I said I intended to. I drove the D6 down the access road at 8 in the morning on a Friday in May with Donnie Reese, walking beside the machine taking photographs and video on his phone. The morning was the particular kind of Tennessee spring morning that my grandfather would have called a good day to work, clear, cool, the kind of light that makes the tree line look like it was painted rather than grown. I found the cable gate where Donnie had said it was, approximately 40 yards inside my right-of-way boundary, established by the boundary markers I had personally replaced with fresh painted posts the previous fall. I photographed the gate from 6 angles. I photographed the Alliance padlock. I photographed my boundary markers on both sides of the installation point. Donnie was recording video continuously. I called Roy and said I was about to proceed and described what I was looking at. He said, "Go ahead." I aligned the D6's blade at the base of the near gate post and applied forward pressure at low speed. The post, a steel T-post that had been driven into my road surface, not set in concrete, came out of the ground in approximately 4 seconds with a sound that I found genuinely satisfying, the sound of an unauthorized object being returned to its original condition of not being in my road. The cable went slack. I nudged the gate assembly to the right shoulder of the road with the corner of the blade. The road was clear. I shut the machine down and sat on it for a moment in the quiet. The timber operation was not affected by any of this. The cattle were not affected. The hunting lease continued. What was affected was the lodge site, which was a clearing full of debris and a foundation and a fieldstone pile where my fireplace had been, and which I looked at every day for the following 3 months with the combination of grief and purpose that I imagine anyone feels when something they built with their hands is taken from them against their will. The criminal investigation moved at the pace that criminal investigations in rural counties move carefully and without the urgency that civil litigation sometimes produces. The district attorney's office reviewed Travis Goad's report and the supporting documentation in July and issued arrest warrants for 2 individuals. The driver of the pickup truck, a man from Knox County named Earl Sweat, who had a prior record of property-related offenses, and a second man who had operated the skid steer, identified through a combination of the gate camera footage and a tip from a county equipment dealer who recognized the skid steer model and trailer from a recent rental. Gerald Fitch was not charged directly. The DA told Roy privately that the corporate layering between Fitch and the LLC that owned the truck created a proof problem at the criminal standard, and that the civil case was the better vehicle for reaching Fitch's personal liability. Roy amended the civil complaint in June with 6 additional counts. The amended complaint named the Alliance, Gerald Fitch personally, and 3 other Alliance board members who Roy had evidence were aware of the demolition plan before it was executed. Douglas Hale withdrew as the Alliance's counsel in July, citing a conflict of interest, and the Alliance retained a Nashville firm that Roy described as competent but expensive, which he said was significant because the Alliance's budget had not been designed for expensive Nashville litigation, and the financial pressure would likely accelerate a settlement discussion. He was right. Settlement discussions began in August, 6 weeks before the scheduled September merits hearing. The discussions were managed through mediator, a retired circuit court judge named Howard Briggs, who had mediated land disputes in East Tennessee for 30 years and who had, Roy told me, a reputation for making people see the size of the hole they had dug before they dug it deeper. I attended the mediation in person. Gerald Fitch was across the table. It was the first time I had seen him in person. He was a large man, physically, with the bearing of someone who had been used to rooms going his way for a long time and was finding the current room unusual in that respect. He did not look at me when he came in. He looked at his attorney and at his papers and at the middle distance above the table. Judge Briggs ran the mediation with the unhurried authority of a man who has heard more excuses than he can count and is no longer interested in new ones. The settlement that was reached after 8 hours of mediation contained the following. The Alliance formally acknowledged that it had no legal authority over my property and agreed to record that acknowledgement in the Harmon County Register of Deeds, which meant it would be attached to my property's title chain in perpetuity. Gerald Fitch personally, through his holding company, agreed to pay $580,000 in damages. This number represented the replacement cost of the lodge, plus the 17 years of use value Roy had calculated, plus my legal fees, plus a separate amount for the emotional distress and the trespass. The Alliance's charter provision purporting to govern non-member property was formally rescinded and a corrected charter filed with the county. The Alliance agreed to dissolve within 18 months, which effectively meant Gerald Fitch's governance vehicle was done. Janet Fulton called me 2 days after the mediation concluded. She said she had wanted to call since the day the lodge was demolished, but had not known what to say. I told her I had never blamed her for any of it and that I appreciated the call. She said, "Cole, I want you to know that when I found out what had been done, I went to the board and told them it was wrong, not just legally wrong. Wrong." I said I believed her. She said she had submitted her resignation from the Alliance that same day. I said that took character. She said, it took about 20 years too long. We talked for a few more minutes about the county and about the land, and then said goodbye. I broke ground on the new lodge in October. I had the foundation assessed. It was sound. It had survived the demolition without structural compromise, which a poured concrete footer on good soil will do if it was built right in the first place, and mine had been built right. I hired 3 men from the county to frame it with me over the fall and winter. I did the fireplace myself. It took 8 weeks this time rather than 6, because I was 51 rather than 34, and my back reminded me of the difference between those ages with considerable clarity. But the work was the same work, and the stone was local fieldstone from the same creek bottom I had pulled the original stone from. And when the last course was laid and pointed, and the throat was clean and ready, I built a fire in it and sat in front of it on a folding chair, the only furniture in the unfinished great room, and listened to the fire talk to itself in the way fires do when the drawer is right and the wood is dry. Donnie Reese came out that evening with a bottle of bourbon that had been waiting for the occasion and 2 glasses, and we sat by the fire and didn't say much for a long time, which is the correct thing to do by a good fire in a building you have built yourself on land that is yours. The morning after, I drove the perimeter, 812 acres of mixed hardwood and creek bottom and ridge line, the timber operation on the east side, the cattle pasture in the center, the southwest corner where the lodge was taking shape again against the tree line. I rolled the truck window down as I drove and let the November air come in, which smelled like wood smoke and cold water and the particular mineral smell of clay soil after a frost, which is the smell of East Tennessee in November and which I have been breathing my whole life and which I expect to be breathing for whatever portion of my life remains. Gerald Fitch sold his property in Harmon County the following spring. I heard about it from Travis Goad, who had heard it from the county clerk, who had processed the deed transfer. The buyer was a timber investment company from Kentucky. I did not know the people. They were not my concern. My concern was my 812 acres, which had been mine before Gerald Fitch arrived and were mine after he left, and which required from me the same things they had always required: attention, work, respect for the land's own rhythms, and the willingness to protect what was worth protecting. My grandfather taught me that land is patient. It does not get upset. It does not negotiate. It does not ask you to justify your ownership. It simply is there, season after season, and it asks only that you be there too, paying attention, doing the work. I have been paying attention for 51 years. I will be paying attention for as many more as I get. Thumbnail text, **. They wrecked my lodge. I brought the bulldozer.